May it please you, my lords, my lady. It is clear from my learned friend's submission this morning that his emphasis, or the emphasis of his case, now lies on indirect discrimination. It is also obvious now that my learned friend has very candidly admitted it, that the object of this case is to develop the law in a manner beyond the state which it is now in. My lords, in order to do so, my learned friend has relied quite heavily on South African and Commonwealth jurisprudence. I would much rather, my lords, drop anchor nearer to our shores and stay close to the European Court of Human Rights jurisprudence, which is more attuned with the issues which arise in Europe and how things are perceived. And I would submit that in order to persuade your lordships, my lady, to depart from the consistent, to succeed, my learned friend has to persuade this board to depart from the existing clear and consistent ECHR jurisprudence, much of which, I would add, my lords, is very recent. Lords, as my learned friend said this morning, Gibraltar is a party to the European Convention of Human Rights. It has been extended to it. This is obvious from the case of Matthews, which is included in the bundle. There's no issue on this. But we also have our constitutional provisions. And I would wish to visit section 14 of the Constitution, which is at page 19. From that subsection, that the jurisprudence of the European Court of Human Rights is to have a direct bearing of the obligations and then section 14.3 goes on, whereby persons of one description are subjected to disabilities or restrictions, to which persons of another such description are not made subject or are accorded privileges or advantages that are not accorded to persons of another such description. And what that does in my submission is it adopts, for the purposes of the definition of discrimination in the Constitution, the tests of analogy. My lords, my learned friend took your lordships and my lady to section 18.8, which provides a court or tribunal determining a question which has arisen in connection with a right or limitation thereof set out in this chapter must take into account any judgment, decision, declaration or advisory opinion of the European Court of Human Rights. As your lordship construing anything, whether in a positive or a negative way, the was my learned friend did not appear to press the ground of appeal on direct discrimination, but the ground remains on the statement of case, so I feel I have to address it. We have dealt with it in our paragraph 4 of our statement of case. I will go later to the judgment of Sir Paul's judgment, but at this stage I would say that Sir Paul made quite clear that what was not required was further justification. And it's clear that in his judgment, Sir Paul considered all the relevant facts, considered the line of politics which has been cited to. Those circumstances where further justification is not just a slip, but it shows that the court did in fact go beyond the mere analogy test that is applied on this present standard. And looked at the situation more in the light. I would like to take you to Horek and Slovakia, which is a useful case. This is a volume 4, tab 3. And it's useful because it considers the test of discrimination. It considers analogy and dismisses the application on the sole ground of analogy. Our position is that it is an integral part of discrimination that the person complaining must be complaining that he has been treated in a less preferential way than somebody else who is in a comparable position. And that would be the end of the matter. But our second position is that is not what the Court of Appeal in Gibraltar did in any case, because they went further than that test. I have to press the yellow button. So. But all the circumstances are set out at paragraph 3 of the judgment, or the nature of the case. The applicant complained under Article 14 in conjunction with Article 8 of the Convention that he had been discriminated against on the ground of gender, in that he had been denied the right to succeed to a tenancy after AZ's death. On account that they were both men, he challenged in particular the domestic court's position that his relationship with AZ had amounted to merely an economic community and not to a long-lasting life community. This amounted also to a violation of his right to a fair hearing guaranteed by Article 6, paragraph 1 of the Convention. If I may take your Lordships and my Lady to paragraph 83 and 84 of the judgment. Then I might take your Lordship's my lady to paragraphs 89 to 91 of that same case.
This is really a burden case without the sibship, isn't it?
It is indeed, my lady, and at paragraph 92, the court says as much. The court considers that similar considerations to those relied upon in burden are applicable to the distinction made between family members on the one hand and unrelated persons on the other. Notwithstanding the potentially close nature of the relationship between the two unrelated people, the court considered that the two situations are not comparable for the purposes of Article 14. But that is a broad statement of principle, my lords, my lady, which in my submission applies to this case as well. And this is a recent case. It's only a 12th of May 2009 decision. My lords, my lady, paragraph finding of discrimination requires a combination as to whether there is a treatment between the complainant and others in quality. While those others are in an analysis of whether the privilege similar situation to the complainant and whether the privilege in treatment has an objective and reasonable justification, which means that the treatment difference in treatment is different names and bear a reasonable relationship to proportionality to that date. In our submission, all three conditions must be met. Therefore, discrimination does not arise if there is no difference of treatment, or if the complainant and those controlled for comparison are not in an analogous relevant similar situation. And our case is that the distinction in this case is a simple decision based on marriage, and that the state is entitled to draw that distinction. It is not a distinction based on sex or sexual orientation. It is between married couples and all others, save for the exception of unmarrieds who have a child in common. And in those circumstances, my lords, my lady, it is our submission that there is a wide margin of appreciation, both in relation to the issue of marriage and in relation to the issue of housing. Lords, if I may go to Carson, which is a tab 12. Let me refer your lordships, my lady, to page 179, paragraph 3, in the opinion of Lord Nichols. For my part, in company with all your lordships, I prefer to keep formulation of the relevant issues in all these cases simple and non-technical as possible. Article 14 does not apply unless the alleged discrimination is in connection with a convention right or a ground stated in Article 14. If the prerequisite is satisfied, the essential question for the court is whether the alleged discrimination, that is, a difference in treatment which the complaint is made, can withstand scrutiny. Sometimes the answer to this question would be plain. There may be such an obvious, relevant difference between the claimant and those whom he seeks to compare himself that the situations cannot be regarded as analogous. Sometimes, where the position is not so clear, a different approach is called for. then the court's scrutiny may be best directed at considering whether the differentiation has a legitimate aim and whether the means chosen to achieve the aim is appropriate and not disproportionate in its adverse impact. Well, our submission is simply that in this case, the distinction based on marriage is so obvious that the claimant and married couples cannot be analogued with each other.
But that's treating the ground of discrimination as synonymous with the analogy, which is part of the problem. Sex discrimination is not acceptable, even though, of course, what you're saying is the ground for the discrimination is sex. It's a circular argument. You're saying the ground for the discrimination is marriage.
Yes.
And marriage makes them differently situated.
Yes, my lady, but
that is treating the ground for the discrimination as what makes them different.
I will be coming to that aspect of the argument later, my lady, if I may. But if I may reply briefly, to take that argument and to reverse it, that would require the state to introduce legislation for homosexual couples to be able to marry in order to eliminate all discrimination on the grounds of marriage.
It could be argued so to do, or it could be argued to say, which as I understand it is what the appellant's case is, and they'll correct me if I'm wrong, that where marriage produces differences in treatment between different people, one has to look to see whether that difference in treatment can objectively be justified. And I think they would further accept that it may be comparatively easy to justify some distinctions based on marriage, whereas other distinctions based on marriage would not be so easy to justify. That's as I understand their case, and the case
yes,
you have to meet.
My lady, and my response to that, with respect, would be quite simple. In issues relating to housing, there is a wide margin of appreciation, and the state is entitled to draw a distinction based on marriage, because after all, if the provision of housing is a preference which the state cannot give married couples, then what sort of preference would be permissible at all? Because that is one of the most basic requirements for the promotion of family life, the provision of a home.
Very true, and that's the complaint. That
Indeed.
these people are a family just as much as a married couple are a family. That's the basis of the complaint.
But we're talking about a married couple, my lady, married couples and non-married couples.
We're talking about people who can and are married, can marry and are married,
Yes.
and people who can't marry and are not married.
Indeed.
Those are the sets
issues,
of
yes.
people. And the only point that's being made against you is that the second group, the people who are being treated less favourably, are just as much capable of being a family unit as are the married couple.
Yes, except this case does not turn on family rights. Well, my lady, if I may, my lords, also paragraphs 14 and 15. Then I refer you to paragraph 30 in the opinion of Lord Hoffman.
Paragraph 13.
Yes,
Yes.
paragraph 30. The real difficulty about the questions is apparent. Lord Hoffman, paragraph 31 goes on, there is a single question, is there enough of a relevant difference between X and Y to justify different treatment? Secondly, the invocation of the rational and fair-minded person, who is of course a judge, suggests that the decision as to whether the differences are sufficient to justify a difference in treatment will always be a matter for the judge. In many cases, however, the decision would be a matter for Parliament or the discretion of the official entrusted with statutory powers. And in my submission, in matters of marriage, the matter is for the discretion of Parliament. Lords, my lady, if I may move on to paragraph 412.
Sorry, what tab is that, Mr. Neal?
It's tab 49.
Burden, yeah.
The statement of the court that I would emphasize is in the absence of such a legally binding agreement between the applicants renders a relationship of cohabitation, despite its long duration, fundamentally different to that of a married or civil partnership couple. This view is unaffected by the fact that, as noted at 26 above, member states have adopted a variety of different rules of succession as between survivors of a marriage, civil partnership, and those in a close family relationship, and have similarly adopted different policies as regards the grant of inheritance tax exemptions to the various categories of the survivor. And then the Grand Chamber concluded that the applicants as cohabiting sisters could not be compared for the purposes of Article 14 with a married or civil partnership act couple.
Can sisters enter into a civil partnership?
No, obviously. In Corton,
how far does this principle go? What if you said that as marriage policy, we're not going to issue passports to those who have, who are not, to couples who are not married?
but that would be a matter which the court would immediately recognize as being totally irrational
and unrelated to the right of the state to distinguish on the basis of marriage.
Well, why is this? Is it axiomatic that it's rational when you're considering a couple who have an established family relationship living together in a flat? Why is it axiomatic that it's rational to discriminate depending upon whether they are married or unmarried?
My lord, there is a general policy, not a specific decision in relation to the individual applicant and her partner. And my submission on that is that the state is entitled to distinguish on the basis of marriage, and that in the field of housing, it has a wide margin of appreciation. And if it is perfectly entitled to provide housing for the purposes of pursuing the legitimate aim of furthering marriage. I can only answer your lordship's question in general terms and not in specific terms. Lord Gaydon is at volume 4, tab 50.
Very similar to the fact of the case. The argument of the fact that the latter had entered into a binding relationship was not relying on the distinguishing feature, as at the time gay couples had no choice about whether to enter
An equivalent arrangement. It was this element of choice which made it possible to compare and distinguish married heterosexual couples and civil partners and those who cohabited without a legally binding agreement. And then 2 paragraphs further down, as to the substance, the court records that under Article 14, not every difference in treatment will amount to discrimination contrary to this provision. It must be established that other persons in an analogous or relevantly similar position in assessing whether and to what extent differences in otherwise similar situations justify circumstances. The subject matter changes, marriage remains an institution that is widely accepted as conferring a particular status on those who enter it, and indeed it is singled out for special treatment under Article 12 of the Convention. It has held, for example, that the promotion of marriage by way of limited benefits for surviving partners can be afforded to the respondent government. Shackle in the United Kingdom, see also Lindsay. Would not claim to be in an analogous situation with an unmarried couple where public and binding obligations towards each other. The judgment, therefore, is of no assistance in respect of the applicant who lives with his partner in a long-term but informal relationship. The applicant is pointless to the remainder of the relevant life with no choice of his own to enter into a legally binding arrangement into marriage. Since the facts of this case were later arranged before the Civil Partnership Act 2004, which the legislature has ratified the formal mechanism for recognizing the legal effect of the relationships, including as on the 27th, 2005 exemption. However, in the area of evolving social rights, where there is no established consensus, states must also enjoy a margin of appreciation
government cannot be criticised for not having introduced two candidates from the Installation Act and Allocation, and thereby enabled the applicant to obtain the benefit of the inheritance tax exemption conferred on the survivor. So that's relying quite heavily on that case for all the way. So that we can more forward with our situation. It is a recent case. Volume 4, page 54.
Mr. Nish, what was the date of the court decision?
2008. The 4th of November 2008.
That's it.
But the relevant margin of appreciation is in relation to timing. One's got to look at the actual timing it was looking at. Do you say that this is applicable to Gibraltar and that it's simply a question of Gibraltar saying, well, we're entitled to take our time before we take a step which we are obliged to take in due time of legislating to allow civil partnerships? Or do you go further and say Gibraltar's under no obligation at all to take steps towards that goal?
My Lord, I would say that Gibraltar may become under an obligation in due course when the circumstances require that civil partnerships be introduced. But that is a matter for the legislature to determine. At the moment, my Lord, I would submit that the legislature does not deem that the time has come for civil partnerships to be introduced in Gibraltar. So therefore, it would not be at this moment in time in breach of its obligation. My Lords, Serif Egit, tab 54. I would only wish to take your Lordships and my Lady to paragraph 29, which is at the very end of the judgment.
I'm sorry, which case are you referring to, Mr. Hedge?
Serif Egit.
The last one.
Thank you.
Tab 54 for volume 4.
Thank you.
Rather than the duration or the joint and several nature of the relationship, the determinant element is the existence of a commitment which goes alongside a range of rights and obligations which are contractual in nature. In the absence of a binding legal agreement, it is not unreasonable for such legislation to grant protection solely to civil marriage. Thus, I say that the broadly rule that marriage remains an institution largely recognized as conferring special status on those also, Article 8 cannot be interpreted as requiring the setting up of a special regime for a particular category of unmarried couples, Johnson and others aforementioned. Johnson and Ireland is a rather old case. It's a 1986 case, but it seems to have been affirmed and followed by the court in Yigit, which is a 2009 case. And then in paragraph 13, the specific circumstances of this case, the court considers that the difference in treatment in terms of benefits given to surviving partners between spouses and unmarried persons has a legitimate aim and is supported by objective and reasonable justification. That is, the protection of traditional family life based on marital relations. appellant's arguments are emphatic for the following reasons. To the extent that the appellant claims an assessment
whether the complainant and those put forward for comparison are not in an analogous, relevantly similar situation, it is no longer necessary or sufficient to dismiss a claim for discrimination. It is respectfully submitted that the proposition is wrong as a matter of law. And as to paragraphs 21 to 25 above, any assessment as to discrimination must address this issue. Further, if the court finds that this condition is not met, this in itself is sufficient for the discrimination claim to be dismissed. And as Judge Lukaidis categorically stated in his dissenting opinion in Sidabras and Lithuania, it is established case law that Article 14 safeguards individuals placed in an analogous or similar or relevantly similar situation. Marx and Belgium, Van den Massel, Stubbings, therefore, as pointed out in the case law, for a claim of violation of this article to succeed, it therefore has to be established inter alia that the situation of the alleged victim can be considered similar to that of persons who have been better treated. All the cases cited by the appellant to support both the propositions predate the European Court of Human Rights judgments in Burden and Curtin. And in both of these cases, the European Court of Human Rights unequivocally dismissed the applications on the single ground that the applicants were not in an analogous situation to married couples. And we submit that it is therefore unsustainable for the appellant to contend that the case law she relies on shows that the European Court of Human Rights is moving away from the comparator analysis, or of having changed its attitude, or of having to establish justification in cases where it has found that the applicant and those put forward for comparison are not in an analogous situation. And then as far as the requirement for justification, again we say that none of the cases cited by her support her argument. As far as the appellants reliant on Summerfield in Germany and here in the United Kingdom, these are applicants who sought to compare themselves to a couple living in a subsisting marriage. In any event, in both cases, the European Court specifically found that the applicants were in an analogous position to those of comparison. Hence the need for the court to always consider whether the difference in treatment was justified. Michael, dealt with the question of analysis in a careful manner, but so too on the question of justification, dealt with the Wallace is Abras in Poland. The alleged need to ask a wider question whether legally created differences were justified. In my submission, none of these two cases can be interpreted in the manner put forward by the appellant. If I may refer you to Waller is at volume 3, tab 31. And it's clear that this case was decided on the issue of compatibility. On page 8, paragraph halfway down, the applicants may therefore claim to be in a comparable position to the mandatory life prisoners as regards this aspect of their detention. In Sidabras, volume 3, tab 42.
Tab what?
42, my lord.
42. Volume 4, yes.
Volume 4. And this case was decided, my lords, on the basis, again, of direct comparables. Paragraph 51, according to the court's case law, a difference in treatment is discriminatory if it has no objective and reasonable justification. That is, if it does not pursue a legitimate aim, or if there is not a reasonable relationship of proportionality between the means employed and the aim sought to be realized. And then paragraph 55, in view of the above consideration, the court accepts that the restriction of the applicant's employment prospects I would just refer your lordships to, my lady, to paragraph 54. My lords, I would just, my lady, I would just adopt the concluding statements which are set out at paragraphs 415, paragraphs 42 to 46. If I may turn now to section 416, the House of Lords judgment in VG.
Yes.
Tab 16. refer your lordships to paragraphs 34 and 38. This is tab 16 of volume 1. Paragraphs 34 to 38 in the opinion of Lord Hoffman. Lords, and my submission is that what Lord Hoffman said in those paragraphs should not be extended beyond what, in my submission, they actually mean, which is that, A, in certain situations, it is for the court to exercise the margin of appreciation which lies with the state. But also that this function should be exercised by the courts, in my submission, when there is an interpretation of domestic legislation in issue. In this case, it is my submission that what is required in order to place same-sex couples with heterosexual married couples is legislation to enact civil partnership contracts or civil marriages, and that, in my submission, is a matter for the legislature to decide.
Well, here it's the administrators who decide.
In this particular case, yes, my lord, but in this case we have a curious situation, perhaps I might, because the appellant's concern is that she wishes to ensure that her partner succeeds to the tenancy in the event that she were to die. But the fact remains that the legislation which exists in Gibraltar now, the Housing Act, which replaced the Housing Special Powers Act, does in fact limit the rights of succession inter alia to spouses. So the policy, assuming your lordships were to find the policy is unlawful, and then the administrator goes back and says, we've been told this by the Privy Council, so we've got to change our policy. We will change our policy by saying, by not allowing anybody else to acquire joint tenancies. That would still leave in place the Housing Special Powers Act, the Housing Act, which only allows spouses, which by definition excludes same-sex couples who cannot marry, in place. Now, to some extent, it is, I must say, so surprising that if there is an attack on the basis of indirect discrimination, that the legislation itself has not been attacked. And I just ask myself whether that is as a result of an acknowledgement that the legislation is, in fact, beyond attack on this point.
Presumably, again, the appellants can speak for themselves, but presumably the point is being made that joint tenancies are granted, joint tenancies have this effect. So what is under attack is the policy of granting joint tenancies. They may have an effect which is, of course, similar, not identical, to the effect of the succession provisions in the Act. But there is no need to attack the Act because this policy exists, it is there, it is done.
My lady, in respect of spouses, the policy has no effect whatsoever, because if there is a spouse who is not a joint tenant living with the deceased tenant at the time of his death, then she will succeed to the tenancy on his death. And the effect is only, the difference only arises in relation to unmarried couples with a child in common. And the reason for that is to protect the interests of the child. Presumably the family courts would not have jurisdiction in the case of unmarried parents to decide who should keep the tenancy, and if the father is in fact the tenant, and the court would, in the case of a married couple, award the tenancy on the dissolution of the marriage to the mother. it would not be able to do so in the case of unmarried parents. But it can do if there are joint tenants.
Right, I mean, I'm slightly puzzled about this right of succession. Presumably, if you've got a single tenancy, it's a tenancy for life. And so there wouldn't be anything to succeed to when the tenant died.
So they granted tenancy.
Or is it-
That if a spouse has been living with the tenant
Yes.
for a particular period of time immediately preceding his death, the housing department will grant the surviving spouse
Yes.
Same in English law. It's family members living with the tenant is the way it's done in here, I think.
That's right, Lord. It's in the Housing Special Powers section of 11.
Yes. We went to its section 12, wasn't it?
Yes, that can be placed by the Housing Act, the relevant provisions of the section.
Well, this is then perhaps an indirect attack on those provisions.
I'm sure, my Lord, that my learned friend Mr. Singh had considered there was the slightest prospect of attacking it.
Yes.
We'll see what it does. I'd be allowed to confer with my learned friend.
Yes.
Well, I then move on to indirect discrimination. Our position is set out in paragraphs 53 to 59. I would like to refer your Lordship related to which is at volume 5, tab 57.
And if I may, I would refer your Lordship, my lady, to page 51, paragraphs 63 to 67. And our point on Maruko, my lords, is that the state had chosen to place same-sex marriages and married couples in a comparable situation, and hence not in a significantly different situation. And that's why the matter was referred back to the domestic court to determine whether there were any significant differences between the two types of relationship which would warrant a difference of treatment. Lords, I won't deal with paragraphs 422 and 423. Well, but that has to some extent been clarified this morning when my learned friend corrected the submissions to indicate that his comparisons were not with a married couple, but with unmarried heterosexual couples. Treating the applicants in the same way as with unmarried heterosexual couples was discriminatory. Lords, as far as the indirect discrimination principles, I would refer your lordships to our paragraph 43, and would rely on Johnson and Ireland. We refer there to Sarif, the passage which I have referred your lordships and my lady to, and also Burden. And as far as matter Estebis is concerned, we would point out that that case arose at a time when there was no provision in Spanish law to recognize civil partnerships. Lords, I've already referred your lordships and my lady to Curtin, so I will not do so again, but I would reiterate the submission that Curtin is a very powerful authority in our favour, and we rely on Curtin heavily. Lords, we rely on the remaining paragraphs of our statement of case, which I don't think the lordships would thank me for reading out. Then move on to justification. The appellant contends that the Court of Appeal erred in concluding that the policy in question did not discriminate against the appellant because the preference which it gave to married couples was a positive preference of a kind which the law regards as acceptable in circumstances such as these, and which did not require further justification, per Sir Paul Kennedy, with whom Sir Murray Stuart-Smith agreed. My lords, we would submit that in the light of the authorities, there is absolutely nothing wrong with that statement by Sir Paul Kennedy. There was no discrimination. The parties were not in an analogous position. But in any event, Sir Paul obviously looked into the nature of the preference which was being given, and came to the conclusion that there was a positive preference of a kind which the law regards as acceptable in circumstances such as these, i.e. in matters where there's a wide margin of appreciation, and which did not require further.
As I understand that, it must apply only to direct discrimination, mustn't it? It's pointing to a difference in treatment and considering the question of justification in that context.
Yes, because I think support dealt separately with the question of indirect
Right.
discrimination. He dealt with that part very summarily by saying it was a positive
really, on all these aspects, your case comes back to a very simple proposition, that marriage status is accepted as carrying with it certain legal benefits and requires no more justification than that.
Yes, well,
That's really what it comes down to.
that is what it comes down. That's been our position.
Yes, yes. Yes.
From the outset, on the basis of marital status, not sex, or sexual orientation. But we would go further, and we would say that in any event, the Court of Appeal went further than the mere analogy approach, and it did in fact look at the surrounding circumstances. It did look at the lawful preference to
My Lords, my Lady, there is a point in accordance to law, which is being made by my learned friend, Mr. Rupinder Singh. If, with your leave, if I could invite my learned friend, Mr. Yamas, to address you on that specific point, it won't take more than just a few minutes.
Certainly, yes. Thank you. Yes, Mr. Yamas.
Thank you. Thank you, my Lord. My Lords, my Lady, this issue arises as a result of various statements that the appellant has made in her statement of case to the effect that the respondents declined to challenge the tentative view expressed by Mr. Justice Dudley that the policy pursued by the respondents was not in accordance with the law. And the appellants infer from that we refuse to challenge the findings made by Mr. Justice Dudley against us on the question of justification. I refer you, my Lord, my Lady, to paragraph 65 of the appellant's statement of claim, statement of case. This is one of the introductory paragraphs the appellant makes in relation to ground 4 of the appeal on justification. And in paragraph 65, she says that the policy pursued by the respondents required justification. And in the second sentence, she says, further, the question of justification did not arise since the respondents had declined to challenge the ruling of Mr. Justice Dudley on justification. In the following paragraph, paragraph 66, where she's criticising the findings made by the Court of Appeal, again, she concludes the last 3 lines of the paragraph by saying, and notwithstanding that the finding of the learned judge below on the absence of justification was not susceptible to challenge in the absence of a cross appeal. She makes a similar statement in paragraph 45, to which I won't go. My lords, my lady, the points of law and the cross appeal that she's referring to is set out in paragraph 15 of her statement of case, to which I do refer you. So paragraph 15, the appellant accurately in our submission summarizes what Mr. Justice Dudley said in the relevant passage of his judgment. Justice Dudley went on to hold that the respondent's policy was not in accordance with the law, and that had he accepted that there had been discrimination against the appellant, the proper approach would have been to decide that the policy was not in accordance with the law and to find a violation of the Constitution without turning to consider justification and proportionality.
That phrase, in accordance with the law, that doesn't come from the Constitution, it comes from the jurisprudence of the...
Precisely, my Lord, and I'll be coming to that point. Paragraph 17 deals with the cross appeal, or rather the absence of a cross appeal. The appellant appealed against Mr. Justice Dudley's refusal to grant the declaration sought. The respondents did not file a notice of cross appeal in relation to the findings referred to in paragraph 15 above, which is the paragraph I have just read out, which, as we see, deals with the question of the condition in accordance with the law. And similar statement is made in paragraph 22 of her statement of case, where she restates accurately that we have not cross-appealed on this issue before the Court of Appeal, or indeed here. Therefore, the argument that is being made by the appellant, which is not without its significance to these hearings, is that since we did not cross-appeal the learned judge's tentative view that the policy was not in accordance with the law, it is not now possible for us to argue justification. Now, my lords, my lady, it is our strong submission that the condition that a measure be in accordance with the law has absolutely nothing to do with justification. These are two entirely different matters. I refer you to the passage of the judgment given by Mr. Dudley, which is in the Record of Proceedings, Volume 1, at pages 104, 105.
The expression in accordance with the law is used in connection with specific convention rights in the...
Absolutely, my lord. It's used in relation to the conditional rights in the convention. In this case, it's in Article 8.2 of the convention. The way, as my lord certainly knows, the way the conditional rights work is that there could be an interference with the right protected under Article 8, paragraph 1, but that interference is not in itself sufficient to make a finding of a breach. The state is still allowed to show that it has complied with the three conditions set out in Article 8, paragraph 2 of the Convention. Those three conditions being in accordance with the law, the measure was in accordance with the law, pursued a legitimate aim, and was necessary in a democratic society.
And there's a division of authority on what in accordance with the law means.
I'll explain in a second, my lord, why our position is that in the judgment, that is what Mr. Dudley was referring to, the condition in Article 8.2 of the Convention. I mean, I'll tell you quickly now why I think that is that before Mr. Justice Dudley, the appellant was making two different arguments. She was arguing discrimination, both under the Constitution and the common law principle of equality, but she was also making a separate claim, which she has now abandoned, and she abandoned before the Court of Appeal, which was a pure breach of Section 7 of the Constitution, which is our equivalent of Article 8 of the Convention. And therefore, those submissions were made in the context of the pure breach of Section 7, in other words, the equivalent of our Article 8, where it was necessary to show that the measure was in accordance with the law. I'll develop that point in 1 second. So coming back to what Mr. Justice Dudley said, he refers to the arguments made in page 104 by Mr. Singh about the matter being, the valid point made by Mr. Singh that in accordance with the law provision requires the law interfering with the protected right to be compatible with the rule of law. Such compatibility requires the legal regime allowing for the interference with the right to be ascertainable. And he goes on to cite the judgment of the European Court of Human Rights in Halford versus the United Kingdom, which was a case under Article 8.2. And the test which Mr. Singh set out this morning, but which we'll just reiterate quite quickly, is that the expression in accordance with the law requires first that the impound measure should have a basis in domestic law, and it also refers to the quality of the law in question, requiring that it be accessible to the persons concerned and formulated with sufficient precision to enable them to foresee, to a degree that is reasonable, the consequences which a given action may entail. Therefore, what accordance with the law means, it's got to be set out in the law has to be accessible, and its provisions have to be foreseeable. None of those three elements of the tests of in accordance with the law have anything to do with justification. And it is on that basis, my Lord, that we would invite you to dismiss those statements made by the appellant in her statement of case to the effect that because we did not cross-appeal Mr. Dudley's findings on the condition of in accordance with the law, we are now barred from arguing justification, which is indeed an argument we have made all along during the life of this case, from the first hearings to this to today.
Well, as I understand the way this works, it works in stages. First, this legality argument, first you've got to identify an interference with a qualified right that has to be justified.
That's right.
The next stage is to look at whether there's justification.
Correct. Absolutely.
But the interference, before you even get to your justification, the interference must be one which the law permits or is in accordance with the law.
My Lord, I would go even further. There has to be, and I think Mr. Justice Dudley misdirected himself on this issue. There has to be an interference in the first place.
Yes.
Mr. Dudley never found that there was an interference with the Article 8.1 right. In other words, what he was required to establish before considering the condition of the law was that the respondent's failure to grant Ms. Ms. Muscat, joint tenancy, was a breach of Ms. Rodriguez, the claimant's rights to the privacy of her home. An argument which Mr. Dudley never addressed, and which indeed has been abandoned by the appellant in the later proceedings in this case, which have become a case exclusively about discrimination and not about a pure breach of Section 7 or Article 8 of the Convention. But that is what was before Mr. Justice Dudley when the case was heard.
Doesn't that then raise a question that if in this situation it's now common ground that discrimination is a freestanding cause of complaint, and if you are making a cause of complaint of freestanding discrimination, does that introduce a requirement to demonstrate that the discrimination is in accordance with the law, i.e. the basis of the discrimination is clear. And the point is being made, I think, that the basis of the discrimination that's complained about is not in the Act, it's in the policy. And therefore,
My Lord,
there's lack of the necessary legal clarity which you need to justify your discrimination.
I don't see that requirement in section 14 of the Constitution. I think we're in section 14.2. If you refer to volume 1, tab 4 of the authorities, section 14, which is on page 19, I think it is common ground, and Mr. Singh can correct me if I'm mistaken on this, but I think it is common ground that we're in section 14.2, subject to subsection 6, 7 and 8, no person shall be treated in a discriminatory manner by any person acting in the performance of any public function conferred by any law or otherwise in the performance of the functions of any public office or any public authority.
You say there's either discrimination or there isn't.
Exactly. And that is in contrast to subsection 1, which specifically refers to a law. Subject to subsections 4, 5 and 7, no law shall make any provision that is discriminatory either of itself or in its effect. And indeed, I do not see anything in subsections 6, 7 and 8 to which subsection 2 refers, which makes me change my mind.
Well, I suppose it could be said, I'm not saying it is being said, that subsection 7 provides an exception or a justification for discriminatory treatment if the matter falls within section 7 and is justified under section 7 subsection 3.
Correct.
And the argument would go that section 7 subsection 3 does require the thing to be contained in or done under the authority of any law. And that is a way of bringing in the requirement that what has been done by the public official has to be in some way authorised by law.
Except that we would say there's no discrimination in this case.
Well, we understand that's what you say. That is the burden of your song.
Yeah,
absolutely.
But if we get past that, which is, of course, a matter to be decided, then the point is being put that you can't get out of it by relying on an authority for these actions, these discriminatory actions, if they are, which doesn't pass the test of legality because subsection 7 doesn't help you. Now, I may be misstating the appellant's case, and Mr. Singh will tell me if I am, but that may be the point. It's certainly not the way in which Mr. Justice Dudley looked at it.
No.
No.
What this case is all about is which couples do get a joint tenancy and which don't. And you don't find the answer to that question simply by looking at the statute.
Yeah.
You don't get the answer to it by looking at anything, in fact.
No. That's what I understood to be the point, that it's not good enough to say, well, there's no discrimination. If people are being treated differently, but it's not clear the basis upon which the differential treatment is being administered.
Especially as there is evidence of a joint tenancy being given to a same-sex couple, which makes it even less clear.
I mean, this might have been open to challenge just under traditional judicial review principles.
My lords, my lady, the purpose of my intervention was to address that point of, in accordance with the law, which, for the reasons I have attempted to put forward to you, do not amount to abandoning or indeed not having made any arguments on justification, which we have indeed made all throughout this case. Our position has always been there's no analogous situation, there's ample and consistent case law to that effect, but even then there is a justification which pursues a legitimate aim as consistently recognised by the Strasbourg jurisprudence. Thank you, my lords and my lady.
Lord, my lady, as far as justification and we're running out of time, and I would purely rely on the written statement. There's no point in. I would like to make a point in relation to section 18.8 of the Constitution, which arises from 4.5, because the appellant complains that the Court of Appeal context of my learned friend's arguments on the common law principle of equality, Justice Dudley seems to have reverted back to the Iranian English expression. He says, to my mind, the common law principle of equality is not advanced with Rodriguez's case any more than the constitutional argument. Applying the principle of equality must determine who a same-sex couple is preferred or compared to. Determined in the constitutional argument that was being handed opposite sex couple. I cannot deny that there is some logic in Mr. Seal's submission that the comparator should be a married couple. But if I were to accept such a submission, I would be usurping the power of the legislature. My view, apparent from the Strasbourg law case law, that the legal recognition of same-sex and opposite-sex couples is a matter which does not have broad consensus. It is likely unlikely that there is consensus in any one state. In those circumstances, when and what states to be afforded to those relations is not for this court to determine. So, a matter which would fall within the margin of appreciation. In my friend's case, is that there is no margin of appreciation in domestic legislation, in this case the Constitution. Nonetheless, there is an issue which is, in my submission, consistent with the remarks made by Lord Hoffman in BG. And that is a matter which is of such importance that it is for the legislature to decide and not for the people. Maybe anything I can have, I can usefully add anything to what I have in the statement of case.
Thank you very much, Mr. Nish.
My Lords, my Lady, would it be acceptable if I do my reply sitting down?
Yes, certainly.
I'm grateful.
At least one member of the board would welcome that course.
The first topic I'd like to deal with is what exactly has been under challenge in this case, and to clarify our position on that. It is the administrative practice which governs, as we understand it, the granting of joint tenancies in Gibraltar. And that practice is not confined in Gibraltar to unmarried couples with a child in common. It includes married spouses. That's clear from the agreed précis before the board at paragraph 1, if I can just read from that, and this is based upon the witness statement filed by the government by Dr. Coram, and his witness statement deals with the point at volume 1 of the record, pages 43 to 44, at paragraphs 8 and 11. But the précis summarises what he says in his evidence, and it says this: applications for joint tenancies are dealt with by the second respondents on the basis of policies which have evolved over time, and he says they're not codified in any form. Applications for joint tenancies are generally approved if the application is made by a married partner, a parent, an adult child, or a common law partner. And he goes on to say that applications from common law partners are only granted if the common law partner of the tenant and the tenant have at least one minor child in common living with them. So, in my respectful submission, the proceedings have always been aptly brought against the administrative decision pursuant to what we were told by the respondent was an administrative practice not set out in writing, but, as Dr. Coram says in his evidence, evolved over time and not written down. It's common ground that there is such a discretion. Otherwise, they wouldn't be able to grant anyone a joint tenancy outside the terms of the statute. So the classic administrative law question then arises: has the exercise of public power been conducted in a manner which conforms with the law? And of course, the law includes, for present purposes, a constitutional Bill of Rights. My Lords, my Lady, can I deal next with the topic that Mr. Llamas made submissions about, the topic of in accordance with law? Before I proceed with this, may I make one thing clear, because I wouldn't want to make a false point. My Lord Phillips asked whether there's a fundamental problem here that the administrative policy is not written down in the statute itself. My Lord, in fairness, I would have to accept that that by itself is not fatal, because it's well established both in Strasbourg and in the House of Lords, cases like Munjaz, a mental health case, come to mind, that where there is a statutory framework which permits the administration to set out how it will conduct itself from time to time in documents like codes of practice or circulars, things of that, we would accept that that can, in principle, satisfy the requirement of law. But we go on to submit, my Lord, and this is the fundamental problem in this case, that even so, such formulations of policy have to satisfy the quality of law requirement. They must be formulated. Here, because they're not written down, the public can't see what they say, and of course, necessarily, they are not accessible. And that's the fundamental absence of law in this case we submit. Now, how does it arise in this case? In our respectful submission, it does. First of all, it is a fundamental, if it arises, it's a fundamental hurdle. And whether or not it's regarded as distinct from the requirement of justification doesn't matter in law, because take the case of Holford. I won't go back to it unless I'm asked to, but it's in volume 2 at tab 24. And the board may recall that Alison Holford was the senior police officer whose telephone communications had been intercepted in her workplace. And the position in English law at that time was that following the Interception of Communications Act 1985, which had been enacted in response to the Malone judgment, this country did have a statute governing telephone intercepts in private communication, so the home. But there was no legislation at that time which governed intercepts of someone's telephone conversations while they were at work. And that's what she was complaining about. And what's of note about the judgment of the Strasbourg court is that once they had held that it did not satisfy the requirement of law, that was the end of the case. The government lost the case because the government was then not permitted to try to justify the interference. And so these are cumulative and independent requirements which the state has to satisfy. And it's for that reason that we have perhaps laboured the point unduly here, but it's clearly one that attracted both the acting Chief Justice and Sir Paul Kennedy, at least on this point.
But you deploy it in relation to discrimination pure and simple.
Yes, we do.
Yes.
And can I finally on this point explain to the board how we get there? And my lady was essentially right, if I may say so, to anticipate how we put it. The only element in the analysis that we would wish to add is that it's not just that there's a requirement for authority of law in section 7, in subsection 3, but also in section 14, subsection 7. So because the exception to the discriminatory conduct in subsection 3 has to satisfy 14.7, on our interpretation of 14.7, it includes the requirement that the interference is under authority of law. And we would respectfully invoke a more general and fundamental principle that the whole of constitutional law, in a sense, and certainly the Convention, is infused with the notion of law, that we are a society governed by law, and that therefore whenever the executive interferes with fundamental rights, including, we would say, the right to equality, it must act in accordance with law. If it can't even satisfy that requirement, then it fails. Lord, that's the argument. Can I deal more briefly with some of the other points that have been made? The reference was made to express provisions in the Constitution which cross-refer to the ECHR, and we accept that, and I hope I made that clear right at the outset this morning. Section 14.3 and Section 18.8, of course, do, but they are of limited assistance to the respondents in this case. Section 14.3 simply helps the court to understand what are the prohibited grounds in Section 14, because they can include such grounds as have been said by the European Court of Human Rights to be prohibited. And it's common ground in this case that they include sexual orientation. And in our respectful submission, 14.3 offers no more assistance than that. It certainly doesn't say that the Gibraltar courts, including for that purpose this board, cannot go beyond anything the Strasbourg court has ever decided. Section 18.8, I hope I've dealt with adequately in opening. It's a take account of provision, and we rely upon G under the Human Rights Act. Many of the cases that my learned friend Mr. Niche cited were decided in Strasbourg and concerned what he said was the wide margin of appreciation to be afforded in the contexts of marriage and of housing. Can I deal with each in turn? The first observation we make is that the margin of appreciation is a doctrine of international law, not of Gibraltar constitutional law. Secondly, we make the observation that although there may be a wide margin of appreciation in relation to marriage, it's not an absolute discretion given to states. See, for example, G in the House of Lords. And the third observation we make is that we do not accept my learned friend's premise that the margin of appreciation is wide in the context of housing when it comes to discrimination.
The policy in this case, in any event, isn't directed towards the protection of marriage as an institution, because it allows unmarried couples to take advantage of it in certain circumstances.
My Lord is right about that. And I would like, if I may, before I conclude my reply, to come back to that observation. I'm grateful. But just on the point of how wide, even in Strasbourg, the margin of appreciation would be, just because this is a housing case, we remind the board of Kana, which concerned very similar facts to do with succession rights in the context of landlord and tenant law. And yet, because the discrimination was on ground of sexual orientation, particularly weighty reasons need to be advanced. Gaydan, similarly, in the UK under the Human Rights Act. My Lords, my Lady, can I go on, perhaps to pick up my Lord Collins' point about what the underlying rationale of the policy is? And I would respectfully agree that whether a discriminatory measure which distinguishes between married couples and others, including same-sex partners, is justified in a particular context will always depend upon asking questions such as whether there is a rational connection between the measure and the end in view. My Lord Phillips gave the example of a refusal to give people passports. And my learned friend fairly and rightly accepted immediately that there would be no rational connection. Similarly, I would say my example of the allocation of public sector employment. So merely to invoke the mantra of saying it's based on marriage is clearly not enough for the respondents to win the case. We suggest with respect that the true rationale of a policy such as the present one is that it's concerned to give security of tenure to people in relation to the family home. And so you choose, for example, of course, understandably, you choose spouses to enjoy that. But if you find that there is another kind of relationship, and we say here there is, and I don't repeat what we've said about the South African case law, but they are a stable, long-standing, intimate relationship and so on. My clients are living in a marriage-like family situation. And this is what the case is all about. They are worried about what will happen on the death of my client, the appellant. And I would respectfully endorse what my Lord Collins said a moment ago to me, that it's not really, at the end of the day, a measure which is designed to protect the institution of marriage as such. What it's really trying to do is to find suitable families who are occupying a home together and asking, should they have the security of knowing that if one of them dies, the other one will be all right. And where the line should then be drawn by the state is what the case is all about. No one is disputing that in an allocation of limited public resources, lines can be drawn. But what we say is that they can't be drawn in a constitutionally impermissible way. They can't be drawn in a way which discriminates against same-sex partnerships in particular. And that if they are to be drawn at the line of marriage, then that has to be justified on an objective and proportionate basis. My Lords and Lady, the last point I'd like to make is that the submission for the appellant in this case does not lead inexorably to the legal consequence that the state has to introduce legislation conferring either the right to marry on same-sex partners or necessarily even civil partnerships. That may come, others may want to make that argument in other cases. I don't preclude those arguments, but it's no necessary part of my case. And I say that for this reason, that if one analyses what happened in South Africa, Satchwell predated Fourie by 4 years. The legal position in South Africa in 2002 at the time when cases like Satchwell were decided, as I understand it, was materially the same legal position as in Gibraltar. In other words, marriage was not open to gay people as a matter of law, and there was no concept of civil union or partnership made available by the state. And so what the Constitutional Court of South Africa was really saying in our submission was that it may well be acceptable for the state to have a law governing marriage which stops at opposite-sex partners. It may well be acceptable not to have any equivalent civil union law. But what the state can't then do is to use that distinction to give benefits in a discriminatory way.
But here, the Housing Allocation Committee, on your case, could have a policy that joint tenancies could be granted to A, married couples, B, unmarried couples with a child, and C, unmarried couples without a child who have lived at either together or at the relevant premises for a certain period, 3 years or whatever it is.
Yes, yes. So certainly in the case of same-sex partners, and that's really the Satchwell point, that it may be that if a subcategory of those who are excluded at least have the legal opportunity to marry, they may not be able to complain.
Now, I was making a different point, which is that there could be a uniform rule for unmarried couples, same-sex or opposite sex, without children.
Yes, my Lord is right about that, yes. All I would say in response, my Lord, is that, of course, I understand the sensitivity of the argument. What's said against me, and I have to face it, is that where you have limited public resources available, that the state is not required necessarily to confer those rights on all unmarried couples. I squarely face up to that and say my answer is the same as the answer given by the Constitutional Court of South Africa in Satchwell and the earlier immigration permit case, which is fair enough if that's where you want to stop the line. But what you can't do is discriminate against same-sex partners at a time when you, the state, have chosen in your legal system not to give them either the right to marry or the right to have some equivalent union. My Lords and Lady, I just wanted to clarify one other thing, which arose not so much in my learned friend submissions, but this morning my Lord Phillips raised with me the question of whether structurally the Constitution in South Africa was different because Section 9 of their Constitution has this element of unfairness being required. We can yes, deal with it. Can I clarify that it's by reference to a judgment we did look at earlier, which is Satchwell at tab 64 in volume 4. And can I just give the reference for now? Volume 6, forgive me, tab 64. And it's Justice Madala, paragraph 20. And Justice Madala was referring back to an earlier leading case of Harkson and Lane. My Lord may remember that. Essentially, the point is this, that what Harkson laid down is that if the prohibited ground invoked is specified in the Constitution, as sexual orientation is, then unfairness is presumed. It's only where, as the law develops over time, as inevitably it will, that new grounds may come to light in the light of emerging social attitudes where we hadn't previously thought of them, they weren't expressly set out in the Constitution. If you're going to invoke a new ground, then you have to show that the discrimination is unfair, and one can see the underlying philosophy behind that. Probably you're going to be looking for the sort of personal characteristics that have already been set out in the Constitution. But the essential point is there's no material difference with Gibraltar because sexual orientation is prohibited in both jurisdictions. Lords, my Lady, unless I can assist further, that's my reply.
Thank you. The board is grateful to counsel for their submissions and will take time to consider what advice they will humbly tender to Her Majesty.